I told you earlier that in order to bring a medical malpractice case, we are required to bring in a medical expert to support our claim, to show that there's wrongdoing, that the wrongdoing caused injury, and that the injury is significant or permanent. Can any of you tell me what is the three-word Latin phrase that we can use in order to bring a medical malpractice case without the need for bringing in a medical expert? Excellent. Very good. The three-word phrase is res ipsa loquitor. And now, for all of you who don't do medical malpractice, you see this come up in contracts. You see it come up in other issues. But how could we possibly use this concept in medical malpractice cases? Okay, we're not dealing with contracts here. We're dealing with improper medical care. So here's what happens. My client goes in for surgery to fix a problem with his left hand. He comes out of surgery and is told by the nurse, your surgery went great. But by the way, you have a bandage on your upper right shoulder. You suffered a third-degree burn during surgery. You need treatment for that. And the patient says, wait a second, I went in for surgery to fix my left hand, and I come out of surgery with a third-degree burn on my right shoulder? You must be kidding me. Well, in that instance, can we use what's known as res ipsa loquitor, the thing speaks for itself, to prove our case without the need to bring in a medical expert to support our claim? The answer is yes. But before you come to that conclusion, here's what you have to know. In order to get the benefit of coming in with a case where you don't need a medical expert to testify, we have to look at three things. We have to look to see whether this type of injury is something that would not happen but for someone's negligence. We have to look to see whether or not the patient caused or contributed to her own injury. We have to look to see whether the patient was in the total and exclusive control of the doctor or the hospital staff. If the answers are all affirmative to each of those situations, then and only then can we now use res ipsa as part of our claim, not as a separate pleading, but as part of our claim in the bill of particulars, so that we no longer have to bring in a medical expert to testify. So let's examine it. The patient was under anesthesia. Do you think she caused or contributed to her own injuries? The answer is no. Was the patient under the exclusive control of the doctor or the hospital? Well, the answer obviously is yes. She's under anesthesia. She can't control anything that happens in the operating room. So in that instance, the answer is yes. And the third is, would this injury have occurred but for someone's carelessness? The answer, no. It turned out in her case, what happened was that they were using a device known as a cautery instrument, which is used to burn bleeding blood vessels. And during the course of using it, they inadvertently touched the covering the rest of her body. That caught fire in the operating room. And the surgeons and the nurses didn't recognize it until there were flames shooting out. And by the time they recognized it, put it out, she had already suffered a third-degree burn. So in that instance, we would then get the benefit of using res ipsa loquitor so that we need not bring in a medical expert to confirm and prove our case. So at the time we rest our case, we don't have to worry about the defense standing up and saying, Your Honor, I move to dismiss Mr. Oginski's case. He hasn't made out a prima facie case. Wait a second. He doesn't need a medical expert. He's just proved all three elements of res ipsa. Sit down, counselor. So now, let me give you a best practices tip. Even though we can still have the ability of proving our case, showing that we are more likely right than wrong, without the need for a medical expert, I will still tell you it is in your client's best interest to still bring in a medical expert to testify. Want to know why? Because it allows the expert to come in and teach the jury about this type of surgery. It allows the expert to teach the jury about why this injury never should have occurred. It allows the expert to explain to the jury how this incident happened. And by doing that, you gain tremendous credibility with the jury. So even though we're not required to, it is an extremely good practice to now bring in the medical expert to support our claim solely for the purposes of explaining to the jury what happened. Okay, make sense?